Ladies and gentlemen, good day or good evening, wherever you may be. Thank you for taking the time to be with us today. My name is Khaitan, and I'm a partner in Khaitan's corporate M&A practice group. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. This is the fourth in our M&A Master Series over the course of 2021. We've been thrilled with the tremendous response we've had to the M&A Master Series, with literally thousands of people taking up to our invitation to register to attend the series not only from India but also abroad and view our webinar recordings. We are very grateful for the interest and support which our clients, associates, and others have shown in registering for this webinar. This slide is the agenda for today's webinar. In short, the format will be a discussion between our expert panel followed by a Q&A session with the audience questions. We have already received several audience questions, and if you have questions, please send them using the facility provided in the webinar portal. We cannot answer all questions during the webinar. We will respond offline by email after the webinar. Please also note that a copy of the presentation and recording of this webinar will be sent to you after the webinar. The second and third webinars in our M&A series dealt with why and how buyers and sellers, respectively, should do M&A due diligence. This webinar, we will explore and discuss how buyers can mitigate risks in M&A transactions. Buyer identification and analysis of risks associated with an M&A transaction and how to overcome, resolve, and transfer or otherwise deal with such risks are critical to success in every M&A transaction. Buyer due diligence is in itself a part of the risk mitigation exercise in the sense that it seeks to clearly identify key risks and their context relative to the target and its value. We have investigated buyer due diligence in detail in our earlier webinar, and we will not be focusing generally on buyer due diligence today. Other traditional ways that buyers mitigate risk are through contractual assurances, undertakings or agreements with sellers like warranties, covenants, and indemnities, which wholly or partially result in the seller remaining responsible for or assuming responsibility for specific risks rather than such risks being transferred to the buyer. Our discussion today of these traditional risk mitigation devices will be with reference to specific types of risks and how they can be used in different contexts. It should be understood from the outset that buyer risk mitigation in M&A transactions is an incredibly dynamic area and one where those involved in M&A need to be continuously diligent in pursuit of risk mitigation opportunities. For example, we have seen during the pandemic how material adverse change clauses have taken on a very different form in response to the ongoing pandemic and its impact on businesses. Cybersecurity issues can present serious challenges in M&A transactions, and insurers have responded with cybersecurity insurance. To provide some context for our expert panel discussion and to illustrate the dynamic nature of buyer risk mitigation in M&A in India, I want to show a short video from Mandira Gupta, Vice President, Private Equity and M&A Services at Marsh India Insurance Brokers, on warranty and indemnity insurance in M&A transactions. Can we play the video now?
Warranty and indemnity insurance, also known as reps and warranty insurance, is a transaction-specific M&A insurance that provides for losses arising out of breach of rep due to unknown events. To simply put, in a typical M&A transaction, a buyer is expected to do thorough diligence and the seller is expected to make thorough disclosures. And therefore, anything which is outside the knowledge of the insured, that is the buyer, that results in a breach of rep, that is what the insurance policy pays for. The insurance policy covers for all three buckets of reps in an SPA, that is fundamental reps, general reps, and business tax reps. The use of W9i Insurance in India has significantly increased over the last few years. Initially, it was primarily the private equity players who were using it to make successful clean exit, but now even corporates are using it on both the domestic and international transactions. Until a few years back, we only had one or two insurers who were looking at Indian transactions, but now we have 6 or 7 insurers who actively quote on Indian transactions sitting out of London, Singapore, Hong Kong, which include AIG, Berkshire Hathaway, Liberty, HCC Tokyo Marine, to name a few. With regards to cost of a W9i insurance policy, given the general acceptance of the product and increase in insurer appetite, the pricing has softened over the years with a broader coverage being offered. Typically, for an Indian transaction, a W9i policy costs 2% of the policy limit, which is a one-time premium for a 7-year policy. The policy limit is decided by the client, just the way an indemnity would be decided by the client in the SPA. As long as your transaction requires $8 to $10 million of insurance policy, this product becomes commercially viable.
I hope you found the video interesting and helpful. We are seeing this insurance used increasingly in Indian M&A transactions. Now to our expert panel. Every person who has registered for this webinar today has already received an email with full particulars and credentials of our panel, so I will not spend any time repeating or summarizing their experience. Suffice to say, they are all M&A experts with excellent M&A credentials. We are very fortunate today to have 3 leading M&A practitioners on our panel, namely Sumit Roy is an executive director in the investment banking division at Goldman Sachs, Mumbai. CV Raghu is Group General Counsel for the Motherson Group. S. Ramesh, Executive Director, Global CFO, and Head Corporate Affairs of Lupin Limited. In addition, we are joined by my fellow Khaitan & Co. corporate and M&A partners, Prasanjit Chakravarti and Surbhi Kejriwal, who are both very experienced M&A lawyers. So now let us begin with our expert panel members. So as I start, let's start with maybe some of the deal completion issues and risks. So Prasanjit, if I may ask you the first question, the risk of losing a deal to another party. So how should a buyer protect himself from the risk of losing a deal before closing?
Thank you, Hegdevan, and good afternoon to everyone, and I hope you're doing well. I think the first thing is we must understand what kind of risks and issues arise during the negotiation phase when the parties are still doing diligence and the negotiating transaction. I think the buyer is confronted with the biggest risk of it being used as a stalking horse. And what it means is that, well, the buyer does the diligence and then rolls out an offer to the seller. The seller takes that offer, goes around the town to shop for a better offer, and bids goodbye to the buyer and strikes the deal with a third party. To protect this kind of abuse or misuse, the buyer must have a robust ironclad exclusivity arrangement, or it is also known as a no-shop arrangement. But what next? You have an arrangement, you must have keys to that. To this kind of exclusivity arrangement, what you need to have is break-free construct. So what happens is the seller trivializes this whole arrangement and reneges upon the exclusivity arrangement, and there is a pre-agreed liquidated amount which the seller will be required to pay to the buyer. That's the teeth which helps. The third risk which a buyer also faces is that, look, if the fact that it's in talks with the seller leaks out to public at large, its competitors get a wind of what they are planning to do, which is not great news, because then their competitors will also eyeing the same target or possibly try and expand their footprint, and that significantly reduces the benefit, the synergical benefits which the buyer is trying to have. And therefore you must have a robust confidentiality agreement in place with the seller. The other risk is that, well, if the regulators get a wind of what you're planning and you are a listed company as a buyer, 100 questions will be asked at a very early stage, which a buyer may find it very difficult to respond because there's no deal. And every jurisdiction securities laws are drafted in a very wide manner, giving sweeping powers to the regulators. I will give you an example which many of you will relate to how the no shop arrangement needs to be drafted well, and so that the seller doesn't only comply with the letter of it but also spirit of it. In one transaction, what had happened, that the seller, we had drafted it in a manner that, look, the seller will not only enter into a transaction with anyone while they are in talks with us, they will not talk with anyone, and even by conduct, if it is reflective of a fact that they are really in talks with someone else, we can terminate the contract, claim the break fee. And lo and behold, what had happened is that we found that the seller is dragging its feet on many of the CPs, not pursuing the applications with government authorities, lying completely low. And we were burning money because the client was doing diligence on several fronts, it was losing funds and time, of course. So we triggered the termination clause. We invoked a clause that, look, you're not acting in spirit of the no shop clause, and we claim break fee. Thankfully, we didn't have to go the full hog. The seller mended his ways and came back to the negotiating table, genuinely. What it shows is that you don't only need a theoretical clause, you need a clause with teeth and to protect the letter and spirit. So as a takeaway, what are the three deal protection devices? No shop stroke robust exclusivity arrangement, which works in practice to give teeth to that break fee, which is quantifiable and appropriate sum to cover your expenses. And lastly, robust confidentiality agreement, so that deal doesn't become public and really then you are losing the advantage in many ways. So these would be the three takeaways. Hegri, over to you. Thank you.
Oh, that's very useful analysis of some of the competition risks, deal competition risks, how to deal with them. So let's move to another topic of market risk. And Surbi, if I may ask you, how should a buyer protect itself against a material adverse change in market conditions which impact the deal or make it unviable?
Right. Thank you, Hegriv. And a very good afternoon to all my co-panelists and to all those of you who are listening in. Now, at the outset, it's important to understand and acknowledge that market risks in an M&A deal run through the entire deal life cycle, commencing from a pre-contract stage and continuing until after the deal consummation. Now, in my experience in negotiating an M&A contract, the key to a successful market risk mitigant actually finding its way into the contract is for the buyer to understand the kind of market risk it is seeking to protect itself against. Now, let's take some examples of what these risks are very quickly. A regulatory change in law, for instance, as has been the case in auto, pharmaceuticals, renewable sector, and now more prominently in the technology sectors, when we're all talking of disruptive products like cab aggregators, gaming platforms, and blockchain technologies, where legislative changes are often and have a far-reaching impact on deal-making activity. Other market risks are an overall change in the market conditions and economy, like a pricing risk or the nature of the market itself changing, or a force majeure incident, like of course a pandemic, or even a political risk, which is inherent to the sector or the territory in which the business operates. A most recent example is, foreign investments from China being subject to prior governmental approvals. Now, as is evident, market risks by their very nature are external, and often they are not within the control of the contracting parties. Hence, the tools that a buyer must deploy to counter market risks should in most cases be inward looking, which effectively means that the buyer should have the flexibility to A, either alter the deal contours, or B, if this alteration is not possible, then to have the option to walk away from the deal. The most used contractual tool to hedge market risks for a buyer is of a material adverse change, or what we call a MAC clause. But it's very important that this clause not be toothless and that it provides the buyer the right to alter the deal mechanics. It's important again to assess and identify the levels of a material adverse change. Aspects such as an adverse impact on the revenue of the target, the costs, the existing business relationships, and whether the market risk itself was reasonably foreseeable. For instance, while a pandemic induced MAC was very common in all M&A contracts earlier, a mere mentioning of a pandemic is no longer good enough. A worsening of the current situation itself should also find its way into a MAC clause because we are already in a pandemic situation. Now, upon occurrence of MAC, the buyer has certain or must have certain pre-agreed options, which are usually exercisable at its discretion. These include extension of time period for deal consummation until after the MAC effect has subsided, imposing additional pre and post-closing conditions, price renegotiations, so on and so forth. The second most important tool, Hegrev, that I feel for a buyer is the right of the buyer to terminate the agreement, which we M&A lawyers love calling a walkaway right. Now, this is of course the most extreme case and as a last resort for the parties. That is when the deal becomes totally unviable or it cannot be consummated in the form in which it was envisaged. The essential idea here is to ensure that the sanctity of the deal drivers is preserved. And if there is a deviation from that, then the buyer walks away from the deal. So, Hegrev, in sum and substance, this is what I feel a buyer should consider and take into account when he's looking at market risks.
I think extremely well said, Surbhi, and very enlightening and very contextual in today's times. And I'm sure Raghu, with his dozens of deals, I'm sure in this time he has looked at and faced situations of market risk. I have no doubt about it. And he would have mitigated, I'm sure, with the foresight that he. So, moving to another sort of risk, let's look at counterparty risk. And let's talk about how should a buyer protect itself against seller default on the deal. And maybe Sumit, you can throw some light on this.
Thank you, Hargreave, and good afternoon, everyone. I'm delighted to be part of this panel and the discussion. And I think, Hargreave, as you rightly mentioned, counterparty risk is very relevant in the current context, and more so because of the ongoing pandemic. And it is very much out there and maybe escalated. And I think it's very important for the buyers to ascertain the risk, access the risk, and also mitigate the risk. So maybe before I get into the mitigation part of it, I would kind of give some examples and try to outline the kind of risks which buyers have seen, and more so in the Indian context. Risks such as, like, there has been an example where there is a restriction on sellers' ability to deliver the shares. For example, a PE firm entered into a contract with a seller, and actually there were multiple sellers where one has to be very careful. And there was a family dispute, and accordingly, which went into arbitration. So essentially, that's something which could have been avoided, and had they done a better counterparty diligence. Then there are, and especially again, it gets escalated in pandemic, abnormal changes in working capital, because sometimes the seller has a large group, and there are multiple kind of businesses that they run. And we have often seen that there are issuances around intercompany deposits or debt, which one group company takes for the other. And we have seen that play out in a coffee retail acquisition, which happened a couple of years back, and how it panned out. Then the other one is with regards to disclosure around regulatory notices. So we know that there was a foreign pharma company which acquired a large Indian pharma company, and discovered that suddenly there is a huge regulatory disclosure which the Indian pharma company hasn't made, and that led to closure of a lot of factories, and in fact led to financial loss. So these are the counterparty risks which we see in domestically, and especially I think we see a lot of counterparty risk when it also comes to cross-border acquisitions. Like one of the other pharma examples, and maybe Ramesh can throw more light, is where the know-how of the market is very, very important. And obviously, we get tempted into making acquisitions overseas. And one pharma company realized it quite late that once they made a very large acquisition in an European jurisdiction, the laws completely changed over there, and they were left with a large hole in their books. And then also with regards to, I think Surabhi touched upon the fact around geopolitical risks. Now, sometimes companies kind of base their future projections basis some off take of certain minerals from overseas, and suddenly the overseas regulations change, and there are and suddenly the raw material, either the price increases or your access kind of gets curtailed. So I think these are the kind of situations we have seen in the past. And I think there are new early warning signals which I have seen. One is with regards to seller constantly pushing the buyer to close the transaction fast. I think these are also like warning signals, and also willing to close at a lower valuation if you close it fast. So I think these are early warning signals which one should kind of incorporate when they're doing diligence. So I think, having said that, the mitigant, obviously diligence is the biggest mitigant, which I think we have all discussed in a previous panel. And I think in addition to business diligence, one should definitely do very robust counterparty diligence, which sometimes I think we oversee. I think that's very, very important. And I think in addition to the business diligence, one should also do a commercial diligence and a geopolitical diligence, especially if the acquisition is being made in a foreign jurisdiction, which is not known or one has limited kind of know-how. And then obviously there are legal aspects to, or contractual aspects with regards to a parental guarantee, a holdback mechanism for the proceeds that you pay. There can be a set of escrow mechanism, and obviously warranty and indemnity insurance that one can take. So these are the kind of mitigants which one needs to kind of overlay in to kind of prevent counterparty risks in from a buyer's perspective. Over to you, Hagreev.
Oh, thank you, Sumit. I think that is just so important. And, as you were saying that we often overlook, and it just reminded me of my transaction just after the insolvency code came. And there was a buyer who was looking at a target and instructed us that, look, please do thorough diligence on the target. And as soon as we started off, we realized that the seller itself is in a very weak financial position. And we had a chat with our client and said, look, you're focusing all of the diligence on the target. What about diligence on the seller? And soon thereafter, the entire focus moved on seller diligence, because would there be capacity to consummate? Could there be risk between signing and closing? And then could there be a risk that after closing, there could be a challenge to the transaction? And lastly, how would the refs, warranties, and indemnities be sort of enforced? So very important issue. So thank you very much. Moving to the next issue on pricing risk. So over to you, Ramesh. What does a buyer need to do to mitigate the risk of paying a higher price than it should? And who better than you, who's done serial M&A acquisitions on the buy side, to educate all of us on this?
Thank you, Hagreev. Thank you very much for having me on. Let me start with a statement. M&A should be used strategically, not as a tactical tool for short-term gains. From that perspective, I personally believe that doing organic growth is always much better for a company. The point to make here is the fact that when you look at an asset and somebody is selling it, it generally is a fully priced asset. And in that sense, what you actually are doing is converting balance sheet space to P&L and amortizing it over time. So it's important to actually underscore that it's important to actually make sure that you pay the right price. It's buying at a cost and not at all costs. There should be no deal fever involved in this. And more often than not, when it comes to it seems to be so erotic, so exotic. people go all out to look at an M&A transaction. That kind of a deal fever is certainly not warranted at all. You look at a host of pricing mechanisms, in terms of DCF analysis, heuristics, the EBITDA multiple, sales multiple. But personally, I believe the risk in any M&A transaction is so high that you should certainly look at the payback period. How soon can you retrieve the monies that you put into any transaction? There are, of course, other ways of protecting it in terms of earnouts and the like, which is essentially in a contingency value rights that you have in force today. When I speak about the fact that you should be strategic, you should actually buy only when you are going to look at developing a skill set, or if you want to actually gain credibility with a certain sector of customers and the like. It's only for those strategic reasons that you should be looking at M&A. Most importantly, when you look at it, you should be, as Sudhir was saying, the structural changes in the industry, the market dynamics is very important. You know about what happened at the Beta Farm when Dr. Reddy's bought into it. The floor just caved in. So when they bought into that market, it was actually license fair, and pricing was as per market conditions. But as soon as they bought into it, they got into a situation that actually turned into a tender market. The minute it turned into a tender market, prices just dropped. They should have anticipated this, and there were rumors that they were going to be, this market is going to change, and they should have priced their asset accordingly. And of course, Mr. Reddy has gone in public, having disclosed something like that, and that's why I'm talking about it. I could talk about various of the transactions also. We bought into America, a few years ago, into a company called Gavis, where we actually underestimated the market when it came to narcotics. Narcotics was actually booming at that point of time, but soon thereafter, it was the American government had come down on the prescriptions for narcotics, and to that extent, the market dynamics had changed dramatically. Doctors are prescribing less of narcotics, and to that extent, the prices that we had actually paid for the transaction was much higher. You could also talk about, in fact, I spoke about strategy, and strategy is extremely important. And again, to our own disconcert, we actually learned when we actually got the specialty. We, of course, indulged in things like earnout, saying that only if the turnover reaches a particular level would I pay so much and the like. But despite that, unless you understand the dynamics of, say, something like a specialty market, which we learned to our own disadvantage when it came to solo sec purchase. In my previous experience, across M&A in various parts of the globe, including my previous assignment at Germany, whilst I was Henkel, I always learned one thing: taxation becomes an extremely important part. And when I actually buy into emerging markets, I always come across situations where the vendor has actually gone about doing things which a credible seller would not do. So and you'll have always contingencies when it comes to taxation. Doing your diligence on that is extremely important. When you buy, you need to be clear about what you're buying. So let's take this example of when Google bought into into Motorola's full assets. They paid about $12.8 billion, and within a couple of years, they sold the whole business to Lenovo for about $2.8 or $2.9 billion. But what they actually bought into was not the fixed assets. They bought into the cash, of course, the deferred tax asset that comes with it, the liabilities, and of course, what they bought into was 17,000 patents, which is essentially the IP. So one has to be clear about why you're buying this and what is the price that you're willing to pay. Because if you're actually going to buy in order to protect your core business, and that's a very different kind of evaluation. So ultimately, it all rests on dynamics and of course the strategic reasoning that you can attribute to any acquisition. Diligence is always key, but one should also take a long-term view of things. That's my view.
Oh, thank you, Ramesh. That is just invaluable advice, and I'm sure all our viewers will very much value what you've said. So adverse tax consequences, you mentioned that as well. Strike fear into the hearts of every buyer. In this short video presentation, our partner Vinita Krishnan talks about key taxation risks and mitigation strategy. Can we play the video, please?
Buyers in an M&A transaction may face different type of risk, and the ways to mitigate the same may differ depending on the contours of the deal. I would quickly discuss a couple of tax risks which we face in a day-to-day transaction, especially from a buyer's point of view. The first risk is called as Section 281 Tax Clearance Certificate, whereby the risk is the risk of transaction being treated as void. This is because there is a specific provision under the Indian tax laws whereby when a seller sells certain assets, the tax officer has a power to void those transactions, especially if there are outstanding taxes or proceedings against the seller. The assets which are covered are shares, immovable property, plant and machinery, etc. Essence of the section is to ensure the interest of the revenue is protected and the seller, before transferring those assets, comes to the tax officer, seeks a specific permission before the transfer. The first way and the best way to mitigate this risk of a buyer is the buyer asking the seller to obtain a tax clearance certificate from the tax authorities. Word of caution, it needs to be ensured that the certificate is unconditional and the contract suitably is worded and also safeguards the buyer in case the certificate comes with certain conditions. While that's an ideal approach, many a times seller is not forthcoming to obtain this certificate from the tax authority. It could be for various reasons, including there is a time sensitivity of the deal. And since prior to the transfer seller is required to obtain this certificate, it can affect the timing of the deal. In those situations, as a next step, buyer at times requests the seller that give me a reputed chartered accountant certificate on which the buyer can place reliance, and provided the certificate clearly specifies that there are no proceedings or outstanding taxes against the seller. While this certificate is not going to substitute the Section 281 tax clearance certificate requirement, it is essentially like a comfort where a buyer is able to make a reasonable assessment about the tax exposure of the seller and proceed with the transaction with suitable protections such as indemnities and warranties. There are also at times the seller may have certain tax exposure, certain tax proceedings, and the seller may not be willing to approach the tax officer. In those situations, it becomes tricky and it is largely driven by commercial call, as many a times buyer may not be in a position to know what is the tax exposure of the seller. Say for example, the buyer is buying the shares of the target. It is usual for the buyer to do a diligence on the target, but you won't do diligence on the sellers. In those cases, it is advisable that the buyer makes a reasonable assessment of the tax exposure of the seller and also compare with the financial wherewithal of the seller to see that whether the seller would be in a position to honor those tax risks in case they ever are, raised by the tax authorities, coupled with contractual indemnities and representations. Tax insurance in this field is an evolving product for a 281 NOC. Typically, the representations under 281 tax risk are covered as part of fundamental representations or title representations. The second risk is surrounding the withholding tax obligation of the buyer. Especially where the seller is a non-resident, the buyer is required to ensure that the taxes of the seller are properly deducted and paid to the Indian government. If they fail to do so, the tax officer can recover tax interest penalty from the buyer. Also, the buyer can be taxed as an agent of the non-resident seller. Therefore, when the buyer is a resident, non-resident doesn't matter. If they are doing any deal with a non-resident seller, be it a plain vanilla sale of India shares or even a sale of an offshore entity, if it has substantial India assets, there can be a tax trigger for the non-resident seller, and yes, there can be a corresponding withholding tax obligation for the buyer. As far as a resident seller is concerned, from 1st July onwards, the buyer can have a withholding tax obligation under certain circumstances. If the payment is linked with employment or non-compete obligation, there can be a withholding tax obligation on the buyer. As a risk mitigation tool, from a statutory protection point of view, the buyer or the seller can approach the tax authority to determine the withholding tax rate. This is not the preferred approach in most of the deals. The most preferred approach is contractual protection, whereby a seller would be asked by a buyer to give a CA certificate or an opinion confirming the taxability and the withholding tax position of the buyer. Coupled with that, there can be an indemnity obligation on the seller. And the indemnity period, it is interesting to note, for any withholding tax default for payments made to non-resident, the Indian tax laws do not provide any statutory limitation period. But technically that's the case, but practically it has been linked to up to 7 years in the past, and there has been a recent amendment which has fueled a debate whether the indemnity period should be 4 years or 11 years. As far as quantum of indemnity is concerned, either it is uncapped or it is linked to purchase price or linked to 2 to 3 times of the tax exposure with some buffer for the litigation cost. Additionally, the buyer may want to have a parent level guarantee, especially if the sellers are like a fund entity or who have a short shelf life, they may not be in existence for long. And also, when the indemnity payments are made by the seller to the buyer, a tax gross up is negotiated by the buyer. Escrow is also an option available but not so popular. Tax insurance is more a matured product and is also a good option available for the buyer, especially where the sellers claim that they are exempt under the tax treaty and their income is not taxable in India. The buyer should carefully evaluate the terms of the policies and exclusions thereof. I hope what I spoke demonstrates that tax risks are vital in any M&A deal and it pays to be diligent. I hope my observations were useful to you and thank you for your attention. Stay safe.
Let's move on and maybe now deal with a very important issue of business risk. So, Raghu, over to you. What about the risk of changes to the business pre-closing? How is this mitigated? And the second part to this is what about the risk of post-closing competition? Can you really throw some light on these two aspects?
Yeah, sure. Hi, hi everyone. Good afternoon, and hope everyone is safe. Thanks, Ajay, for that question. Just before I respond to that specific question, I think my fellow panelists and others have touched upon some very interesting aspects. So it's very important to contain the business risk. Uh, it's important to have a very sound confidentiality agreement because the business risk is associated with you mitigate that by doing your diligence and all of that. And a good diligence happens only when there is absolute confidence on both the sides that you are using the information only for the purpose of the information. That is normally the fear when a target is sharing information. The second thing is that you need to get into these transactions, and the only way to is that you must have an exclusive arrangement after a particular stage. You can't be. I heard Prasenjit talk about the relevant clause about no shopping. While it is said, it's unless you have an exclusivity arrangement, you cannot prevent the target from doing if somebody is putting up unless there's a legal recourse that you have, because if somebody else is putting a higher dollar on the table, there's always this temptation. So you got to create the framework and create the boundary conditions within which and a time frame within which this whole transaction happens. My belief is that diligence, as much as, and I've seen this, is gets its due, but not the transaction documents get more importance than the diligence. And my caution here would be that diligence is far more important than the transaction document, because any amount of indemnities, warranties, insurances, they're only mitigants. They can never replace your diligence. And when you do the diligence, you get the pulse of the business. And it's like typically, I can give you a couple of examples. The way we do is that we would never get into any kind of a transaction unless we've met all the stakeholders. Now the question can come up that how How does the company allow you to go and meet the customers? How do they allow you to meet their vendors and all of that? Now, if it's a listed entity, obviously there are more restrictions. You get into clean room arrangements where people go meet, see, and only give you the report, and they don't give you all the details. Or you have technical people who go visit factories to see whether the asset that you're buying is actually an asset worth the price that you're paying, because at the end of the day you're paying a price for an asset that you're likely to acquire. uh, Unless we've actually, and this might sound like a cliche, we've actually walked out of transactions where the target has not allowed us to meet customers, because we are in an industry where we know exactly who's vendor. Because in an automotive company, you know all the everybody, but you want to actually go, because if the what are you buying? You buying an asset, and you buying along with that the contracts and the business. Now you're getting into the shoes of a target. If that will prevent you from all the contracts that the target has, then what have you bought? You're left with a few machines, right? And you're not left with any business. So it's so important for you to actually get a sense. I remember many years back, I attended a seminar, similar seminar as when I was a younger lawyer, and this was being conducted by the Mahindra Group, and where their senior strategy head said, uh, Mr. Anand Mahindra's father, when the deal used to happen, he used to have a meeting with the owners of the seller and said, "Are you happy?" He used to ask when the deal was happening just before signing, "Are you happy?" And if he would get an answer saying that I'm happy, but if a but would come in, he would not. He would say, "You guys have not done a good deal," because the moment the other party is saying but, that means they're not happy, because unless it's a win-win transaction, it doesn't really, because you don't want, you neither as a buyer want to cheat the seller, nor you want the seller to cheat you as a buyer. It has to be a win-win. It must be a transition. The employees must feel good. The stakeholders must feel good that you are stepping into the shoes. Unless that doesn't happen, uh, it's never, because M&A signing documents, definitive agreements is only one step. It's actually the integration and transforming that business into a larger business is actually the real fun of an M&A. People normally perceive M&A to be very glamorous, but the actual problem starts after the definitive agreements and after the closing. So uh, I think if there is any specific in terms of post closing, I just missed out that uh, if there are conditions like non-solicit, non-compete, because it depends on what kind of business that you're acquiring. If you're buying a complementary business to your business, then obviously you need to have a non-compete for a particular period of time. But if it's not, so you'll have to play this as the transaction is going. Sometimes you buy an acquisition, grow your current footprint of the same business, or you're buying something that is complementary to your business and you're expanding the scope of that. So if there is a non-solicit, non-compete, these are clauses that have to be very carefully drafted. And the biggest success to all this kind of transaction is sincerity of purpose. If you don't have sincerity of purpose, then it becomes difficult. I will give you another small example which happened in one of the confidentiality deals that we were signing. We were targeting a listed entity in the European market. The management came back, and in that they said, for every breach that you do, you got to pay us 35 million euro. And obviously that created, it put the cat among the pigeons in the management team. 35 million euro for a transaction. And when this whole question came about, the fundamental question that we had to ask ourselves, were we in the business of breaching confidentiality? If you're not in the business of breaching confidentiality, it doesn't really matter whether you write 35 million or you write a billion, for that matter. Now the target was posturing by putting that such a big number. Obviously the number came down, but you got to be very clear that are you getting into an M&A process because you are serious about it, or you are fishing in troubled waters. If you're fishing in troubled waters, it's not the right thing to do. Thank you. Over to you.
Thank you. That was truly insightful, Raghu. And thank you for sharing those experiences truly valuable. And I have to also tell you that you've told us about the Raghu standards which you follow. I think it will be very difficult for everyone to emulate.
No, but it's highly the only thing I would suggest for all lawyers. Many a times we believe that business, and I like what Ramesh mentioned, that you should not be in that fever of buying. You know, it has to somewhere fit into your scheme of things. Just to buy, just to demonstrate to the market, you might hit the headlines of Economic Times one day, but 6 months later, you may not be able to utilize that asset. What's the great idea of that? And we've seen several of those things. And and why do you buy? We only buy, in at least in my honor, we only go for an M&A when our customer tells us to buy something. That's a very interesting. We have never gone scouting in the market. Like if Daimler were to tell us, here's the company, go after them, we will go after them. We have never solicited, but we are known in the market, unfortunately, as an acquisitive company. But market has its own perceptions.
Fantastic.
Yeah.
Tremendous. Thank you very much for sharing that. So let's move to another area of information risk. And Sumit, if I may ask you, what about the risk of key deal information relied upon if that is inaccurate or incomplete or misleading? How do you deal with this risk?
Thanks, Agreev. And I think Raghu touched upon some of them during his conversation, and maybe I'll elaborate upon it. So when it comes to information risk, I think the whole tenet of an M&A is trust. So the buyer and the seller both have to kind of trust each other. And especially while there is a confidentiality clause, there is a risk from a seller's perspective that the buyer may get access to all the confidential information and can kind of use it even if the deal doesn't go through. And accordingly, many a times we have seen that the information which is provided is either redacted or incomplete or is missing a lot of key terms. So I think definitely while the seller may be correct to a certain extent, but I think the buyer needs all the information at its disposal to make a very informed decision. And I think it goes without saying that diligence is very, very important to make sure that we plug any gaps with regards to the information risk. And if there is any iota of doubt in terms of the information not being complete or kosher, the buyer should take more time and do more diligence. Like it's like while there may be overhang of competition, there may be overhang of price increase, but this is kind of an arrow which once you sign a definitive agreement, it's kind of done. So the buyer should definitely use all the ammunition to make sure that the diligence is done. And there are a lot of new diligence checks that we have seen, which have kind of emerged in the new environment. I think some of them Raghu touched upon in terms of channel checks, which is supplier, customers. I think the another important diligence area which has come up is social media checks. So essentially, like all of us are on social media on various platforms, and a lot of times there are customers, there are suppliers who have comments on social media. So it's important to kind of comb the social media and pick up those negative comments. They may be very innocuous to start with, but it makes sense to kind of deep dive into those. Another important area is interviews with management is fine, which we always do, but also interview with one level down, the middle management, the kind of small time employees. I think it's very, very important because essentially you are inheriting them. And many a times they come up with certain nuances, certain stories, which again are very, very important and critical to a decision making. So I think that's very, very important. Site visits have become difficult during the pandemic, and especially in terms of sectors which have physical assets. I think in a recent transaction we did, which involved physical assets, our diligence advisors used drones to kind of survey the facility because of the lockdown. So that's another new, unique way to kind of due diligence. And the idea was to kind of understand whether the structural integrity of the buildings are there or not, whether the buildings exist. I think that kind of the video evidence is kind of good enough to take a decision. And I think The other important thing is also when we do M&As in regulatory heavy sectors, it's very important to kind of go through regulatory correspondences and also do an informal check with the regulator to kind of understand if there are any issues which the buyer should know before they kind of get into a situation. So I think these are the kind of diligence checks, and obviously there are legal mechanisms with regards to warranties, with regards to undertaking and indemnities that we take as a part of the agreement, and also information and inspection rights. So I think these are some of the other ways in which we can try and mitigate the information risk from a buyer's perspective.
I think some very novel and new ideas, and especially how diligence and information risks have been mitigated in these challenging times. Thank you so much. So I spoke earlier about cyber risks in M&A, and this has become increasingly important as regulation in India and abroad has been developed and new jurisprudence evolves. In this short video, our partner Harsh Walia discusses cyber risks and mitigation in M&A transaction. Can we play the video, please?
There is an increasing sensitivity around cyber risk in M&A transactions. So let us quickly find out what are the significant cyber risk in M&As. There could be variety of cyber risk, and a great deal depends on the target and its sector. And it may not be possible to list down all the cyber risks together, but some recent examples will definitely help us understand it better. In my view, undiscovered security vulnerabilities are the biggest risk, and it can lead to both financial as well as reputational loss. Take the case of Marriott Hotels. When it acquired Starwood Hotels, UK regulator Ofcom fined Marriott £18.4 million. And the first part of the cyber attack took place way back in 2014 when the acquisition was not completed. The investigations found that there were failures by Marriott to put appropriate technical and organizational measures in place to protect the personal information it was processing. Therefore, security vulnerabilities should be tracked not just at the beginning of the transaction but up to the stage of integration. So, what needs to be done to mitigate cyber risk in an M&A transaction? I think an all rounded strategy is required, and I'm going to talk about three important areas here: cyber diligence, contractual insulation, and cyber insurance. Cyber diligence means deep diligence into cyber practices of an organization and sometimes involves the services of a forensic expert also. As a first step, check the sector in which you are dealing. Are there any standards that have been prescribed by the regulator for security? Are they being followed properly? Check the nature of targets' data protection systems. Thirdly, find out if there are security agencies which are external and have provided any ratings to the target. And finally, if there is a history of cyber attack or data breaches by the target on the target, that should also be taken into account. Contractual insulation again is an important tool. Warranties and reps are very important here, but specific indemnities should be carved out depending on the outcome of the diligence steps that you have taken. The indemnity should at the minimum cover the cost of remediation and customer or third party claims. Cyber insurance again is a very important tool. The crux is to pay attention to the coverage that is being sought. It should cover the cost incurred in investigations and remediation, any business interruption, third party liability, or even cyber extortion in some cases. So, these will help you provide an effective tool for mitigation of cyber risk. Hope you are able to apply these tools in your M&A transaction and get benefit out of it. Thank you very much.
Thank you. I hope that was useful. So coming back, I think we are coming to the end of our session, and maybe we'll take some audience questions. We have lots of questions from our audience. So I'll start off with the first question, and maybe over to you, Raghu. A question has been raised as to whether you see break fees commonly used in M&A transactions, and what is the position you have adopted, whether or not break fees have been enforceable or not?
Well, break free as a concept, it does exist. we have used it, but you know, you get a sense of the break fee when you are negotiating the transaction. And actually, we've many a times walked out of transactions where the break fee is turning out to be the source of revenue rather than a condition for a breach or something like that. You know, but if it's a reasonable break fee, you know, and it is quite possible just to give protection to the target, it is enforceable, and it's also demonstrative of your integrity in the transaction.
Thank you. Then we have another very interesting audience question, and I think nobody better than Ramesh to answer this. How do you see cultural integration as key in valuation in M&A transaction?
Yeah, cultural integration is extremely important in M&A. So let me go back to my Henkel days. You know, so we bought over this company in America, Loctite. You know, so that is way back in 1994. But let me tell you this: there were very few Germans, not even a single German, being sent across to that particular company for several years to come. To, you know, and it was allowed to be there as an independent company. Leo, 4 or 5 years later, they actually start integrating it. There's of course integration from the back end perspective in terms of all MIS reports and so on. What you can do in terms of an SAP system being in place and the like. But there's a lot more to it. You know, so when you, for example, that particular company had several subsidiaries across the globe in terms, you know, spread across various parts. So so the dividends from those companies first had to go into America, and from there it used to be dividend out to Germany. So what did we do? So over a period of say 5 years, we actually disentangled all of those and then made those subsidiaries to the main company, and thereby we were able to save close to about $60 million. So you need to take your own time and actually the way you integrate it. But let me come back to an even more recent example. When we took over Japan, we didn't send anybody out there, you know, so because essentially we of course wanted to keep supply chain at the top of the agenda, because you need to be on top of your customers, keep them happy. You need to be on top of quality. And for much of the front end, you generally maintain your own, you maintain the Japanese or anybody else that you actually have. So it can't be that you actually put in people from India and that would actually mean, you know, a very different thing, because firstly, they resent it. There's no integration at all. So, you give the impression that it's not like the conqueror versus the conquered, so to speak, or even worse, you know, so essentially, you know, you give them to understand that we're now, you know, out there, we don't trust you as much and so on. So that's not the message that you'd like to give. Integrating them at a pace, and there's no such thing as, in fact, your values are superior, your culture being different. I think it should be a cauldron of values, so to speak. And each one has its own way of going about it. I think it's personal chemistry in some ways, leadership in lots of ways. And there's no definitive formula for this. One has to design it bespoke and see what works for the particular company.
Thank you. Thank you again, Ramesh, for sharing your own experiences. That was terrific. Then we have a question from the audience, and maybe Sumit, if you can take this. What should be an ideal payback period for a strategic M&A transaction? Whether synergy should be included while calculating this payback period?
That's I think $1 million question which we all grapple with when we do M&A advisory. So I think in terms of a optimal payback period, it's difficult to kind of ascertain. Again, and I think maybe I'll go back to Ramesh's point, saying that M&A is strategic and it's not transactional. So I think when a company does M&A, they need to take into account a long term period, and it's not something that you flip in a couple of years. So definitely there has to be strategic kind of intent when you do it, and accordingly then you look at a payback period. And the payback period can work in various ways across customer delight, across revenues, across growth. I think the second part of your question was, sorry, with regards to
synergies should be included in calculating.
Yeah, yes. Definitely. So when it comes to acquisition, I think synergies are very, very critical. I think we need to weigh all synergies, including the revenue synergies and the cost synergies, and also how long. Like, it's not that you get those synergies in year 1 or year 2. They're spread across multiple years. So I think one needs to kind of weigh them also in the cash flows when you kind of decide to pay a certain price for that asset.
Thank you. I think we are running out of time, but we have lots of audience questions. Maybe we'll take two very quick questions. Surbhi, for you, do you recommend buyers opt for W9i Insurance on transactions? What's been your experience?
Yes, definitely. I think it's a good tool. Interestingly, we are seeing a lot of that tool being used in India now. Earlier, it was only in the North American, European markets, but Indian acquirers are getting more and more savvy. So yes, it's a tool one must use as a buyer. But having said so, I think we must realize that it's a tool with comes with its own set of do's and don'ts. So cost is an important aspect. The currency in which we take that insurance is an important aspect, and timing is an important aspect, because if the time that you take to stitch up an M&A W9i Insurance, they will have their own sets of lawyers, they will do their own diligence, and most importantly, the diligence that a buyer has done is totally carved out from that package. Of course, I mean, there could be a little bit, there are a few synthetic products in the market now, but those are not the norm. In a typical W9i Insurance package, the buyer diligence is totally excluded. So it's mostly to safeguard against undisclosed losses. But nevertheless, having said so, it's still a big cushion for buyers. So yes, Hegdeep, I'm a big fan of W9i Insurances.
Thank you, Surbhi. So final question for you, Raghu. This new emerging trend on ESG. So what is the weightage of ESG in M&A? Do you think that, like, for example, the Dun & Bradstreet report, ESG report will become an important part of M&A transactions? What has been your experience?
I think it's a new reality, and we all must, and it's a good reality. Sustainability and sustainability goals and things like that, and every industry has started adopting. So there'll come a period where you'll be left with no choice but to actually evaluate ESG. So I would think the faster people come to terms and start evaluating that as an important criteria, because it also establishes the intent of the organization and how culturally it has grown, because ESG goals are nothing but environment and sustainability goals, and these are things that are of reality, and for every industry it is important. There are UN goals. There are various. Even the Indian government has accepted. SEBI has come out with some guidance on that. So it is important to make that a part of your diligence and give it its due weightage. If you are doing an Indian acquisition, maybe there'll be less because it's not yet developed. But if you get into the European market or the American market, it's highly developed. So it's important to give it the relevant importance. I would think. I think it's something that has come to stay, and a good thing to come to stay.
Thank you, Raghu. So that really gets us to the end of our session. Prasanjit, can I ask you to give us 3 key takeaways from today's webinar that you think the audience should focus on while doing M&A transaction and mitigating risk?
Thank you, Hegdeep. I think some very insightful comments have been made by all our esteemed panelists. 3 takeaways, I would say. The first one really would be identifying what are the key deal drivers, the key value drivers. And once you identify them, also identify the challenges which could possibly erode the value. And all this is to be done through a thorough, robust due diligence exercise, which unanimously all of us have agreed to. But doing diligence is not good enough. Being diligent is equally important, which brings me to point number 2. You have to be diligent enough to know what kind of mitigation strategies you must put in place in order to address the risk which you have identified. And we have seen several suggestions to round up quickly. You have 2 buckets of solutions. One is, of course, your contractual ones, inter-se the buyer and seller, like reps and warranties, indemnities, specific indemnities, break fee, exclusivity period for a good enough period, so on and so forth. The other is really the external ones, like getting an NOC from a tax authority, which Vinita was alluding to, or for that matter, getting a key consent from a key customer. Those kind of issues should be tackled externally. Third bucket is customized bespoke solutions. Today we are living in an age which is driven by internet revolution, different ways of doing business, and we have so many options to choose from. We should look beyond the conventional mitigation strategies and look at some of the options which our panelists have touched upon, like doing diligence through drones, which Sumit touched upon. Then there is, of course, your warranted insurance, which Mandira had spoken about and Subhi had alluded to. You should look at the cyber risk insurance and the mitigation tools that Harsh had touched upon. So many options are there, and the conventional tax warranty insurance, you must have them and to kind of bolster your mitigation strategy. At the end, I will just say the title of this presentation is not risk elimination, it's risk mitigation. And therefore, there is no ideal world or utopian world that you will have a deal with no risk. That's not an M&A transaction, that's a bank deal, a dead deal. In an M&A, you will have to negotiate carefully. Give and take will happen, and you must have all these options before you. And then, well, it's really end of the day a judgment call. What is your risk appetite? What's your leverage? What's your negotiating power? That will end of the day dictate where you end up on all these options we have touched upon. I hope this is helpful. Over to you, Hegri. Thank you very much.
Oh, that was really insightful, Prasanjit, as always. Thank you. So before closing, I would like to ask each of you to respond to the poll slide on your screen to provide your feedback on today's webinar. We take this very seriously as part of our continuous improvement program. The poll slide is up on the screen. Finally, I would like to thank each one of our guests for sharing their experiences and expertise with us today. Sumit, Raghu, and Ramesh, thank you so much. Without you, this webinar would not have been possible. You each did an outstanding job, and we are very much indebted to you. To our audience, I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you a copy of today's presentation materials and a link to the webinar recording. We will also separately receive for your feedback on the webinar. Please take time to send us your feedback, comments, criticism, and even compliments. The form takes less than a minute to complete. Please do not hesitate to contact us regarding any matters arising from this webinar. Our contact information is on the slide at the end of this webinar. Thank you for your attendance today, and we look forward to being of service again at future webinars.
Thank you, Hegri. Thanks.
Thank you, Hegri.
Thank you.